All right, we're talking about protecting your finances before filing for divorce. So here's some simple planning things you can do prior to filing for divorce. Because you got to remember, once you file for divorce, generally in any county in Texas, there is a freeze, a timeout on what you can do with your money. Most counties have a court standing order, no funny business with money after the case is filed. Ensuring that before the case is filed, get all your financial records together. If you've got separate property, get all those records together. Get those important things that you have to have showing your financial responsibility and bill paying, and perhaps the other side's financial irresponsibility. All the trips to blow money on boats, cars, toys, casinos, trips, right? I've spent all my money on bills, raising children, school bus, extracurriculars. Get your ducks in a row and preserve those documents while you still have the access to them all, because at some point, more likely than not going to be cohabitating, not going to have access to all the records, or they won't be as easy to get to. Put all that together, preserve all that either electronically or somewhere where you know where it is and it's safe, maybe even outside the marital home. Second thing that you can do is you can open and move bank accounts. You will not be allowed to do that without getting in trouble with the court after you file for divorce, but certainly before you file for divorce, you can open and move money in different bank accounts. And you can take some steps to make sure that you have some nest egg set aside through that divorce court process, right? Through that, because again, back to almost every county in Texas, or the first order that every lawyer in a county that doesn't have a standing order will be asking for is the no funny business with the money order. They will be wanting to ensure that all the money stays accounted for and frozen, and the bills stay where they're at, and the bills get paid. So there's no disruption of the marital home, no disruption of the children. There's reasons those are put in place. Before those orders go into place, you can move things around, you can protect your records and your ability to get records, and you can put aside a nest egg for yourself. Now, that doesn't mean if there's $20,000 in the joint checking account that you take 19,000. That means that perhaps you might take 10, or you might take 9 and leave some balance in there, both for bills and for the other spouse. You don't zero things out. What you do is you only take your portion. You have the absolute right to do that, certainly before the suit is filed, to protect yourself, to have your own rainy day fund. And after the suit is filed, you'll either have limited or no ability to do that.